Hello, welcome back. My name is Larry Pino. I am the founding partner of Pino Nicholson, specializing in commercial law with a special emphasis on securities. We had done two particular webinars under the Jobs Act. One was for the 506C Reg D offerings, and the other one was on Reg A, both of which were under the Jobs Act in terms of particular new provisions and particular new sections. And we got a tremendous amount of feedback for the office. A number of questions came in, so much so that I decided to go ahead and do another webinar identifying some of those really great questions. Because remember, at all times, with respect to these webinars, you're always invited to call in with any questions that you've got. So with that in mind, we've got lots to do. So let's get started on questions and answers that were actually called into the office. Let me talk about the very first one. What is self-accreditation and how does it apply here? So as you remember, if you've had a chance at this point to have gone through the 506C, in order for you to use a 506C offering, you have to be able to market it specifically and directly to accredited investors. An accredited investor is somebody who has $1 million of net assets exclusive of their home, their personal residence, or $200,000 a year in taxable income, $300,000 jointly for the prior 2 years, and an expectation of doing the same or better this year. In order for you to use a 506C, you need to be marketing directly to accredited investors, and there has to be verification of that. So in other words, as opposed to somebody who just simply says, I am accredited, you actually have to have proof that they're accredited. So one is called self-accreditation, where you say, hey, listen, I am an accredited investor, and that's all you need to know. Or you have accredited investor verification, which is required under the 506C. You actually have to have proof of either net assets or income. So in this particular case, self-accreditation is available through Reg A. It is not available under 506C. So 506C, you need to have accreditor verification. A Reg A, it can be self-accredited. By the way, any of the other Reg Ds, so for example, when you're talking about a 506B, which is the very common one which was used prior to 506C, that is also self-accrediting. In other words, you didn't have to have verification attached to that. So first question. Second question, how do you decide on payouts to investors? And that's a great question. I get that all the time because as part of the process of putting together offerings, it's certainly from my vantage point not very valuable to one of my clients to put together an offering that's not successful. So we have to take a look at what makes the payout successful to investors. And it really is a combination of a number of things. So let me go through some of those considerations for you. The first issue is just simply the general rates of return in the marketplace. Now we all know right now, and this is being taped by the way on September 16th of 2015, the interest rate on virtually any type of money market instrument is certainly sub 1%. So that's not going to mean anything to anybody. So when we're talking about a rate of return on an investment, that doesn't even factor in. Now what would factor in, what would get somebody's attention from an investment standpoint? Certainly something that begins at right around the 7 to 8% range and then begins going up after that. Well, why 7 to 8%? Because an investment intrinsically has a risk attached to it. And that risk is going to be based not only on what that particular asset class is, but also in addition to that, how much and how long your money is going to get, or the investor's money is going to get tied up. So you're still talking about a minimum of somewhere between 7 to 8%. After that, then the question becomes, how high above that do I need to get in order for me to really recognize that I've got investors seriously interested? And that number, and I'm just going to simply tell you, is somewhere around the 10 to 12% mark. For you to get an investor seriously interested in your investment, you're going to have to be at somewhere between an 8 to 12% mark for them to say, hey, let me take a look at this. Now, you've seen investments that have gone much higher than that, 14, 16%, and I'm sure you've heard about those. I will tell you that I tend to stray away from those for a couple of reasons. The first issue is that there's an intrinsic, at that point, lack of credibility when we start talking about returns that are much higher than what the normal rates of returns would be in the public marketplace. So I'm a little bit concerned that you incorporate that into your offerings. But the second is that the higher the anticipated rate of return is, in the event that there's a hiccup or worse, you end up with a severe investor disappointment. And from the standpoint of investor disappointment, if you will, unmanaged expectations or mismanaged expectations, almost inevitably it results in either a regulatory complaint or in a lawsuit. So would it be a fair statement to say that the rate of return that we're talking about for these types of privately held instruments, privately held and privately offered Reg D offerings, is somewhere around 8 to 12%? I think that's a fair answer, and that might be very different if I do this webinar a year from now. But right now, that would be a good measure from your standpoint. Next question. What fees are associated with a 506C, and are they annual? The fees themselves, and I'm excluding legal fees, I'll be glad to talk about that elsewhere, and as a matter of fact, there was a question attached to that, which I'll review at that time. But the actual fees on a 506C relate not to any type of filing fee, because remember, these things don't need to be filed. There is a notice filing provision in some states, not all states, and not in Florida. And for some states that have a notice filing, it's a very, very small amount. It could be as low as $85 to sometimes as high as $200 or $300. But that's on the notice filing. It's not on the filing of the offering itself. And with respect to anything else as far as the actual costs attached to it, you obviously have entities that you have to create. You'd be creating an entity for either your company or your fund, and usually the manager of that company or fund. And those entities' fees are very, very small. They could be, plus or minus somewhere between $100 to $150 per piece. So 506C, other than the legal fees, the costs themselves are not very substantial at all. Can your firm structure a 506C in any state? You bet. Remember that 506C is actually a federal exemption. So because it's a federal exemption and it's under the federal securities laws, it doesn't matter if you have filed it in Florida or you filed it in New York or California or North Dakota, Idaho, Wyoming, any of the states. So the answer is yes, you certainly can structure it in any state. What's the best place to structure it? Best place to structure is wherever you're doing business. So if you're listening to this webinar and you're sitting in Florida, and you're going to be doing business in Florida, then obviously Florida is certainly the place to be doing it. If you're going to be in California, then California would be the appropriate place. And remember that with a 506C, you bypass any type of blue sky. So it's not like you have to do anything on a state level, but for the fact that for a notice filing state, you have to simply file a notice that this 506C offering actually exists, but nothing more than that. Can you raise money for multiple types of assets in a 506C? Legal answer and a business answer. The legal answer is, of course, you can actually use a 506C to raise money for real estate in general. You could do real estate in specific, real estate warehouses, real estate storage facilities, office buildings, assisted living facilities, and so forth. Or you could have a 506C that is setting out opportunities to invest in real estate as an asset class, promissory notes or notes secured by real estate as an asset class, consumer debt as an asset class. You could websites as an asset class, or if you'd like, you can do one for all of those combined. So from a legal question, from a legal position, the answer is no. You could do all of those. You can even put in oil and gas if that's something you do. Now understand, every time you have an asset class, you also have to have risk disclosures with respect to those asset classes. So you don't want to be going crazy here, because pretty soon you're going to have a PPM, a placement memorandum, a private placement memorandum, that has so many disclosures of all the different risks that it starts becoming, I would say, optically cumbersome to be able to do that. However, you certainly can do it from a legal standpoint. Now, what about the business answer to that? When you start diffusing your efforts, you also start affecting your credibility. Investors want to know that you have substantial credibility in a particular category. And is it possible that you might have expertise in more than one area? Of course. That's why, for example, you'll see a fund where there are investments in real estate on the one side and on notes secured by real estate on the other side, because they tend to have a whole lot of investment criteria in common. However, when you start going a little bit way out of that, this fund is going to be used to invest in real estate, and it's going to be used to invest in oil and gas, and it's going to be used to invest in technology plays. Pretty soon, from a credibility standpoint, you start really affecting an investor's perception of you as being an expert in each of those areas. In addition to which, when those areas are particularly diverse in that component, you also, from an operational standpoint, have to recognize that your management has to be far more severe, far more significant, and far more overreaching. So bottom line is, yes, multiple types of assets in one 506C. However, you probably want to be focusing them on the ones that you're not only going to be doing yourself, but the ones that you have the greatest level of expertise in. Can I get a sample of a PPM? Absolutely. By all means, I'd be glad to. We call it redacting. I'll be glad to just simply provide a redacted document that shows you what a PPM looks like. I will also tell you that there are certainly PPMs out there in the web sphere, out there on the internet, that you can take a look at. They're templated, obviously not necessarily appropriate to your type of investment. But at the end of the day, I can certainly provide a sample of what a PPM looks like to you. What are the exact points that must be included in an accredited investor letter? The accredited investor letter is a letter whereby either a third party or whoever is handling compliance for you says, we have taken a look at either the verification of income coming from income tax returns or the net assets of this particular investor individual, and on that basis we have concluded that that person is in fact accredited either under the income test or under the net asset test. That verification letter needs to be given by somebody who has actually physically seen them. So for example, if you've collected those from your investor, you probably don't want to be doing that yourself. You probably want to have an external party review it. That could be a lawyer, that could be an accountant. That would be one source. The second source would be that particular individual investor's professional who assists him or her. It could be an accountant, it could be a lawyer, registered investment advisor, and so forth. So it provides not only the test, that is, are they income or net asset accredited, but it also provides that that person has actually examined the documents which substantiates that they are one of those two categories. Does your firm only set up the structure and file or register it, or do you help manage it? Is it easy to work with the SEC? And I put all those into one because those are all three different questions, but pretty much part of that same conversation. So does your firm only set up the structure and file or register it? We certainly set up the structure, and yes, we do file and register it, depending upon whether it's a 506C or it is a Reg A. Do you also help manage it? We certainly can. So there are investors out, there are promoters out there who want to put together the fund. They don't have a lot of infrastructure, and they are real concerned about making sure that they handle compliance correctly. So they want to focus on the management of their assets. They're going to go out and they're going to buy historical properties, as an example, and they're going to fix up the historical properties. They're either going to keep them or they're going to potentially flip them, as the case may be. So their focus is going to be on the assets inside of the investment category that they're going to be investing in. They don't really want to be focused on investor management, keeping the books, making sure the compliance letters come in, and so forth. And that's obviously where we come in. So not only do we, on the one side, actually structure it, prepare the securities documents, but for those clients who want us to stay involved on a monthly basis, we actually take care of all of that for them, and we do that on just a straight monthly retainer basis. Is it easy to work with the SEC? I will tell you that it depends upon what category of the SEC you're referring. The question is referring to. In this case, it happened to be with respect to Reg A. And I will tell you that my experience initially with the Reg A was certainly strong, working with the SEC on Reg A. My experience post-Jobs Act enactment and the new rules, which went into effect June 19th, is that the SEC has been bending over backwards to be extremely helpful and very easy to work with. Now, they still have regulations and statutes that they have to enforce, so they're not going to be altering on that. They need to do their job. But in terms of timeliness, in terms of returning phone calls, in terms of making sure that they're communicating to you on an ongoing basis so that you know where you sit with respect to the Reg A, they have been extremely helpful and certainly very timely in what they're up to. What are the estimated management fees and what is an acceptable management fee? So again, there's no legal answer to that. Management fee is whatever a management fee would look like. From a business standpoint, however, an investor wants to know that they're going to obtain the rate of return that is anticipated. So generally speaking, you structure a preference. So it's called a preferred return. What does a preferred return mean? It means that the investor is going to get that return. So let's say it's an 8% preferred return before you get any money at all. And then from that point on, you then begin shifting the percentages. So, for example, that the investor is going to get 100% of the first 8% that comes in, rate of return that comes in. If the rate of return is 12%, that's the extra 4%, right? They get 100% of the first 8%, and they get 50% of the rate of return between 8 and 12%. And if it's anything above 12%, they get 25% of that amount, and you get 75% of that amount. So the first aspect to it relates to the type of preferred return that would suggest that the investor is going to get not only their money, of course, but also get the return before you're dipping your toe in the water, so to speak. So that's the first limitation, if you will, on management fees. What investors don't like to see is that you're getting a fee when they have yet to get a rate of return, which is the anticipated rate of return on the investment. Now, if it's a 1% rate management fee, 1.5%, maybe as high as even 2%. That's certainly tolerable within the market, within the industry. Most hedge funds, for example, will range somewhere between a 1 to a maximum for the very, very profitable hedge funds of 2.5% management fees. So that's generally speaking the kind of range you would look at. So you would want to maintain a relatively low management fee to manage the fund, but to get the lion's share of your profit based upon the percentages that you're going to obtain after the investor has gotten the preferred return. What are the fees to set these structures up? And this one, by the way, dealt very specifically with the legal fees to set up these structures. And let me just give you a very broad-based answer. Everyone is very different, of course. You have some funds that are relatively easy to put together, and that the client has come to me and they have a complete business plan. It's in writing. The business plan is laid out entirely for them, for me, and they know exactly what they're doing. Better yet, they actually know the assets they're investing in and have identified the assets. All of those are wonderful because it gives me an opportunity to just focus on the legal stuff. To the extent that it does, it's there and it's already baked into the materials I'm getting. So the only thing I'm really doing is focusing on the legal structuring. Then, of course, it takes a lot less time to put those together. On the other hand, there are literally some, I'm doing one right now, for an individual that has nothing but a concept. And his concept, the concept that he's going to want to be pursuing a fund for is one where he gives me the idea of what he's looking to do, and he wants me to create everything. That's a very different story, because I'm not just creating legal documentation, I'm creating an entire business plan for them. I'm not concerned about doing it because we do it all the time. But just in terms of the structuring of the legal fee, obviously it's a whole lot higher when I actually have to put all of that together as part of the service I'm providing for the client. In addition, it's also a question of what kind of fund it is. Is this, for example, a 506c offering, which is an exempt offering, or is it a Reg A, where in a Reg A, for example, you have to go file it with the SEC, and you're there during the entire time for commentary from the SEC. In a 506c, once the Reg D is finished, once the 506c offering is finished, I give it to you, it's done, we don't change it, and you go forward. With a Reg A, we file it online with the SEC. They come back with their first set of comments. We make changes to satisfy them. They come back with a second set, and then it goes out of technical review and goes to their legal department. And then we have another set, and it can continue on until such time as it's done. So it's a much more time-consuming process with a Reg A. So with all of that, let me just simply suggest to you that the range is going to be somewhere between a low fee of $15,000 legal fees to probably the high end, which is the Reg A that I was describing to you, of somewhere around $35,000. Now, I know that's broad range, but that's about the best I can do. And the only other comment that I would make about that is in having you recognize that that $15,000 to $35,000 does not produce a templated set of documents that I pull off the shelf. I'm sure that you can go to the internet right now and you could probably download these offering documents that you can get for $3,000 or $4,000. First of all, I'd be scared to death to use any of those documents. But on top of that, they're not specifically designed around the particular assets that you're going to be doing in the way that you're going to be doing it, normalized in the market that you're going to be obtaining investors in, and so forth. So everything that I talk about in terms of the fee range that I just described to you is 100% documentation that is original to you with respect to what you're doing and the asset classes that you're investing in. You explained that we will fill out Form 1A when starting the process of a Reg A+. Does that mean we will fill that out or our attorney? Yes, what I was referring to is I would be doing that for you. In other words, to do a Reg A, you're actually filing a Form 1A with the SEC, but obviously that's what you're hiring us to do. Does your firm provide us with the parchment certificates you talked about? Absolutely. I know that it's somewhat of an anachronism to think about these parchment certificates. Do you need them? Of course not. You know, you don't need to have them for an investor, but I will tell you that investors sure like them. And the parchment is just that parchment paper. So yes, when we order certificates, and we order those for you, we order certificates that feel like parchment, so that that investor that you've sent it to feels like they've got that solid investment and they've got that piece of paper that shows that. Are there any requirements for a website for an offering? There's no legal requirement for a website, but if you've gone through the time and the effort of thinking through your business model and you've put together your offering, there's really not a lot of reason that you would not want to have a website. The whole advantage of a 506c or a Reg A is precisely because you can publicly solicit. So if you can publicly solicit, then you would want to get the maximum bang for the buck, which of course is creating a very attractive website to operate as the marketing vehicle for it and for your offering. And remember that you're going to put on your website that this is, in the case of a 506c, only available for accredited investors anyway. So there's no legal issue with respect to that. And from a Reg A, you'll have the requirements of the Reg A right there on there. So no, do you have to have it? Absolutely not. Should you have it? Absolutely, from an effectiveness standpoint. How long is the approval process for a Reg A with the SEC? You know, at this point in time, understand that the new regulations just came out on June 19th. So That's a mere close to 3 months ago. So it's not a lot of history with respect to it, but I will tell you that based on my experience so far with the SEC, it's clipping along relatively well. It depends also on how fully baked the offering is by the time it gets to the SEC. It could fly through in 90 days if that's the case, or it might take as long as 6 to 8 months if multiple modifications are required to this. But it's not going to be because of the SEC. It's going to be because of the type of offering and the type of issues that offering suggests that the SEC needs to be able to either weigh in on or opine or potentially make modifications of. On your 506C presentation, you said we could publicly solicit, but you can also do that with a Reg A. Which one is better, and which one should a real estate investor use, in your opinion? I'm going to say, by the way, that with respect to a category of asset, I don't know, for example, real estate, I don't really know whether one is any better than the other. You can accomplish the same objectives with a 506C that you can accomplish with a Reg A. Whether there's a tax benefit, there's no tax benefit, you're going for the ultimate accreted value, none of that really has anything to do with whether it's a 506C or a Reg A+. So I would just simply take that out of your consideration. The real issue between the two is who you're going to be going after as a prospective investor. 506C, Reg A, both allow you to publicly solicit. So again, that's the constant. However, who are you soliciting for? So there are some types of investments that you're going to focus on accredited investors only. And for an accredited investor, then you can only use 506C. Well, not only, but you can use 506C, and you're limited to the accredited investors. The Reg A gives you the opportunity to go and to have as investors non-accredited investors. So, for example, 506C, you might well structure it where your minimum investment is $25,000, or your minimum investment is 2 units of $25,000 for a total of $50,000. Well, why would you do that? Well, because you're only going after accredited investors for that particular offering. On the other hand, it would be kind of silly to have a Reg A, which is going to be marketed to both accredited investors and non-accredited investors, where you have a minimum offering, a minimum of $25,000. For example, one of the major requirements in a Reg A, or limitations, is that for a non-accredited investor, their investment is limited to 10% of their income or their net worth. Well, that means that $25,000 minimum means that you can only have investors that have minimum income of 10 times that, right? Or $250,000 or $250,000 of net worth. So you probably aren't going to want to use a minimum investment that high when you're dealing with a Reg A. What would a Reg A look like? Probably a minimum investment of $1,000, maybe $5,000, based on the category that you're going to be investing in. So you have the two types, both of which are provide for public solicitation, both of which offer you the same opportunity for access to the investments themselves. So it's really just a question of who you're going after, accredited or accredited and non-accredited. The only other thing, obviously, that you know is that if you do have access to accredited investors and you know that you can go after them, especially based on public solicitation, well, it's worthwhile knowing that a 506C is one which is exempt, so you don't have to go through the SEC process. We can finish up a 506C in a matter of 2 to 3 weeks, as long as our client is cooperative with us. Reg A isn't going to be 2 to 3 weeks. So Reg A could be anywhere from a low of 3 to 3.5 months to 6 to 8 months. So there's also that you would have to factor in. So assets not important, pretty much the same. It's really a question of who you're going after and whether you want to go through the SEC process in the process. What does it mean when you say resell a Reg A plus security, and why would I do that? It's not so much you, it's actually your investor. An exempt security is not offered, I should say, a 506C offering is exempt and it's precisely exempt because the securities are not going to be in commerce. In other words, when an investor invests $50,000 in your 506c fund, they're committing that they are not buying it to resell it. They've got to hold it because there's no public marketplace for it. If there were sales of those, then you would actually lose the exemption, which is why in a 506c offering, you specifically say you may not assign, you may not sell the security. This is to hold, it is not to resell. A Reg A is different because a Reg A is filed with the SEC. So when you have your SEC Reg A approved, you now have the opportunity to have your investors sell it. So whereas you might have a holding period of 5 years for a 506c, you have the opportunity to represent to your investors in a Reg A that by virtue of the fact that these are not listed, but these are securities that have been approved by the SEC, you have the opportunity to be able to sell those without a problem. Now, how you do that pretty much depends upon the method that you create. So, for example, there are actually online exchanges where these securities can be bought and sold. Number two, you can provide a mechanism whereby the company itself, that's you, create a clearinghouse between investors who want to buy and sell, or a particular investor can sell on his or her own account and just simply transfer it internally and notify you once that's been done. So all the different ways that we can do that. Okay, let me finish up these now. I know we're getting behind time. Can you present an offering at a real estate investor club meeting? The answer is absolutely yes, provided that it has been either registered as a Reg A or it has been created as a 506c. If it's a 506c, the only thing that you do have to be aware of is that real estate investor club, the ones that you are presenting the offer to, they have to be in some way identified as accredited investors. So, for example, you have the Investors Club of, pick a city, Chicago, the Real Estate Investors Club of Los Angeles, San Diego, San Francisco. You would identify in the invitation that there's going to be a presentation for accredited investors only on such and such, whatever the real estate classification is. Why? Because remember that that exemption applies to accredited investors. You're not allowed to talk to the general public about it. You're allowed to let the general public know that you've got this offering, but that it is indeed restricted to accredited investors. So you can't just simply have everybody come in the room and then once they're all there, you make a presentation to everybody, because that would not suggest that you had reasonable cause to believe that they were accredited investors when you made the presentation. So, short answer to the question, can you present an offering at a real estate investor club meeting? The answer is yes. And if it's a 506c, it has to be to accredited investors only who have been invited. If it's a Reg A, the answer is no. You don't need to. It's yes, absolutely, you can present the offering, and no, you don't have to identify that they are accredited investors, because a Reg A is available for both accredited and not accredited investors also. So for Reg A, there's no reason to provide any type of clearance ahead of time. Explain the difference between a corporation and an LLC. A corporation is an entity which is created at law. A limited liability company is also. They tend to operate relatively differently, primarily because the LLC tends to be managed by a manager. Corporations tend to be managed by their officers and owned by their shareholders. Why would I use one over another? Primarily at this point in time, LLCs have become far more advantageous for any number of reasons, some of which are tax-related reasons, and those are certainly favorable, but also, secondly, because of asset protection. In a corporation, if I were to get a judgment against a particular shareholder of a corporation, I could attach that shareholder's stock in that corporation. The corporation at that point would have as a shareholder the creditor of one of the investors. On the other hand, with an LLC, if I get a judgment against a member of an LLC, I cannot attach that member's membership interest in the LLC. That's governed by statute. It's different in states, but generally speaking, that's the general rule around the country in the limited liability company statutes. So from an asset protection point of view, an LLC is far more favorable for that reason, plus lots of other reasons on an asset protection point of view, than is a corporation. Also, in addition to that, the LLC does not have the same limitations that a Chapter S corporation has. So, for example, if I want to have pass-through income in a corporation, I have to go through Chapter S. Perfectly okay. However, in a Chapter S, there are limitations as to what kind of entities that Chapter S corporation has, whether they're revocable trusts, irrevocable trusts, and so forth. Whereas with an LLC, there are no limitations with respect to using the partnership form of taxation, that is the pass-through form of taxation, and who the members are. Any of those types of entities and any of those types of structures can be used as members of an LLC. Do you have to have good credit or no bankruptcies to have a 506C or Reg A+? The answer is no, not necessarily, but they are disclosure items. So to the extent that somebody has a bankruptcy, personal bankruptcy of record within the time that is allowable, or in a Reg A+, a bankruptcy, then it's going to be a disclosure item inside those documents. That is the actual offering statements or circulars. With respect to good credit versus bad credit, the answer is it's not necessarily even a disclosure item. First of all, it's kind of, one doesn't identify what the credit rating is in an offering, and what's defined as good credit versus bad credit. So I've never seen a disclosure which provided for credit, but disclosures of bankruptcies, yes, would have to be on those offerings. And that's it. Great. So I think we punched. I wasn't sure if that was the end of the line. So those were just simply questions that came into the office based on the prior two webinars. We'll be doing some additional webinar. Matter of fact, we're doing a live webinar in approximately 2 weeks. And you can get more information on that on our website. But I hope certainly this was helpful to you. And by all means, if any of these questions and answers provoked additional questions, by all means, you could certainly call in. Glad that you were with us and look forward to talking to you again.